Mr Deputy President.
The Leader of the Opposition.
Thank you, Mr Deputy President. I lead for the Labor opposition on the Retail Trading Amendment Bill 2015, and the Labor opposition will be resolutely opposing the measures in this bill. You'd be disappointed if it was otherwise, Peter. The measures in this bill are unnecessary, they're unwarranted, they don't make social sense, and they're not economically necessary. The fact is that in a full year of 365 days, there are 4.5 days where there are restrictions on trading in New South Wales. 4.5 days. And the proposal in this bill is to permit trading on Boxing Day, that is trading to the public. And that, of course, is in the new proposed Section 8, capital A. This provision will allow all shops across New South Wales to trade to the public on Boxing Day. But the real insidious measure is that will it also allow those shops to require their workers, tens of thousands of retail workers, to have to work on Christmas Day, Good Friday, Easter Sunday and before 1 p.m. on Anzac Day, rather than to spend time with their family or at community gatherings. And this is in proposed Section 8, capital A. Section 8, capital A will provide that a shop is not required to be kept closed on a restricted trading day if the only business activities carried on at the shop are receiving, unpacking or preparing goods for sale, and the business activities are carried on only by persons who are freely elected to work on that day. So while 8B talks about Boxing Day, that is trading to the public, 8A allows shops and employers to operate their businesses for those purposes of receiving goods and packing the shelves on each of the other restricted days of the year. So the measures in this bill are much more pervasive and serious than mere Boxing Day trading. To characterise this bill as about Boxing Day trading is misleading and is only part of the full story. Importantly, the bill provides no new protections for retail workers who do not want to work, not only on Boxing Day, but on those other restricted days. The fact is, this term of freely elected to work, it merely consolidates existing provisions in the legislation as it currently stands. In particular, Section 7, subsection 2 and subsection 4, Section 13, subsections 1 and 2, and Section 14, subsections 1 and 2. It recombines and re-articulates those provisions, but effectively it merely replicates the current law. What the bill, proposed of course by the political forces representing employers in this state, does not address the problems that workers in insecure employment who are underemployed face. Many workers, particularly in the retail sector, do not have security of employment, being casuals or part-time. Those persons do not have the sufficient security to resist requests to work. They will feel compelled to work and will surrender their family time. Of course, such workers will not then make a complaint to the department asking them to prosecute their employer. And I'll return to this point, Mr Deputy President, but it's worth noting that retail workers in this state and those in the banking and finance sector are regulated now by federal instruments, federal law, federal laws. And in particular, in relation to the finance and banking sectors, it is quite clear that the clauses in a lot of the industrial instruments deprive the workforce of any meaningful legal right to resist requests to perform work. They simply do not have those rights under the Fair Work Act. The only protection they have to resist working on these protected days, these days that are currently protected, are provided under state law based on whether or not the shops can trade or operate. The fact is, there is no way of providing additional protections for these workers other than to say whether these shops can operate on these days or not. It's pretty much an open and shut case. No attempt to window dress, provide soft soap amendments, trimmings around the edges will really address this key point. So no new protections for workers, and the one protection that exists under state law being removed entirely. Importantly, the legislation before this House does not increase any of the maximum penalties, and although and it should be remembered that although penalty for breaching the Act is a maximum penalty of $11,000, the one and only prosecution to date under the Act for the illegal trading has resulted in a fine of $500 to JB Hi-Fi. And of course, the penalty for breaching an exemption under the existing Act is in fact not $11,000, it's $5,500, 50 penalty units. Now JB Hi-Fi would have made that $500 fine within the first 10 minutes of the door swinging open. So you can see that the penalties that exist as a deterrent are no deterrent. The legislation will result in retail workers and their families losing valuable shared time and community time while not delivering any economic benefit. And this is coming at a time when the retail sector in this state is performing extremely well. Now, the important thing about Christmas Day and Boxing Day together is for many people in the community, these are days of high religious and community significance, which is being significantly undercut because, as I said, not only is this bill about Boxing Day trading, that is trading to the wider public, but it will result in the same shops who wish to engage in Boxing Day sales operating on Christmas Day. And even putting aside the question of religious sensibilities, many persons in our community rely on the 2 consecutive days break to meaningfully reconnect with their families. 2 consecutive days to not work, to spend time with family and friends. But it takes on a sharper meaning when we look at blended families, Mr. Deputy President, families where children have to divide time between different parents. This bill seriously undercuts the capacity for families to share their time meaningfully in a way that is simply unwarranted, whether we're talking economically or socially. The case simply has not been made out for these changes. These changes were pursued by the current government in 2012. It has, and of course they were articulated ahead of the election this March. But it's not about economics for those opposite. It's simply about ideology. They simply cannot bear the idea that the Parliament would intervene in the market to regulate when people can work and when people can have personal, family and community time. And as I indicated at the outset of my contribution, in a year of 365 days, a mere 4.5 days are protected. And now one of those days' protection is to be removed in terms of trading to the public, but in fact the protection in all of these days is being removed. And we shouldn't be surprised, of course, because the current Prime Minister has recently spoken about how we now live in a 24/7 economy. The implicit in such a statement is that there should be no distinction between night and day or one day and the next, whether it's a weekday or a weekend. Well, I haven't seen too many grand finals being played in in the middle of the week. Anyone who has been to a hospital will note that on weekends the activity seriously winds down. Many doctors and other professionals are simply not available on weekends. The fact is, weekend time is very significant in our community, and so are Boxing Day and Christmas Day and the other restricted days. Now, in his contribution, the Leader of the Government in this place made a number of claims about the bill that simply do not withstand scrutiny. The Minister said that the current retail trading regime is complex, inconsistent, inefficient and administratively burdensome. But the fact is that it is no such thing. When the Act was passed in 2008, it preserved all existing exemptions to trade and had a clear expectations that shops would otherwise continue to be closed on the restricted trading days. It also established a relatively simple and clear process where shops could apply for an exemption to trade, but only if they could show exceptional circumstances that it was in the public interest for them to trade. Most applications for exemptions have failed, not because of complexity, inconsistency or administrative burdens, but because they failed to show any exceptional circumstances as to why they should trade on the special days. That was not in the public interest to allow them to trade. The retail sector clearly does not like the regime, but the reason advanced by the government is simply wrong. Another claim was that restricted trading days are stifling growth in this state. Well, with the current laws in place, the New South Wales retail industry has recorded the second highest increase in retail turnover of all the states and territories in the most recent Australian Bureau of Statistics retail trade figures. There are 3 jurisdictions in Australia with absolutely no retail restrictions: Tasmania, the ACT and the Northern Territory. And with the very limited retail trading restrictions in this state, New South Wales has outperformed each of those, both over the last 12 months and in terms of a more recent time frame. The fact is there is no clear case for an economic benefit to the economy resulting from these changes. For example, in the McKell Institute report, Does Our Spending Increase? The relationship between trading restrictions and retail turnover of May 2012, it looked at the differential approaches taken in Victoria about Easter Sunday retail trading, which has changed several times over the last few decades. And what the very detailed analysis from the McKell Institute shows is that the extension of trading hours does not result in a net overall increase in retail turnover. Rather, and perhaps unsurprisingly, it finds that the community actually has a limited amount of money to spend. Those who will spend in the post-Christmas sales will do so whenever the shops are open. The detailed economic analysis showed that there was no correlation between extended trading and additional retail turnover. And consumer spending that occurred on previously restricted days was simply the result of purchases that would have taken place on a regular trading day. Retail turnover overall is driven by consumer spending capacity only, and that spending will occur when the shops are open. New South Wales has already deregulated hours compared to other states. I think of the mainland states, only Victoria allows 2 more days trading to occur on public holidays. So there is no real economic case for the measures in this bill, but there is a very compelling and real social case to maintain the status quo. The government also made the claim that it makes just as much sense for workers, these changes, particularly casual employees, to have the opportunity to earn more money as it does for them to choose the day to spend with their family and friends. And the invocation of choice was paraded as a virtue in this circumstances. Well, there are at least 2 flaws with this analysis. First of all, the claim that a casual employee would earn more money looks at the day in isolation compared to the work allocated to employees over the month or the trading, over the Christmas period generally, or the December-January period. The fact is that wages budgets of retail shops are set as a percentage of sales. While opening on Boxing Day could conceivably increase the sales for that week or that day, overall it may not help the sales for the month. And the fact is, if we're going to move to a Boxing Day sale as opposed to a sale on the 27th, you just bring forward the turnover that would occur a day later. Sales made later in the week or the month are merely transferred to Boxing Day. The overall sales do not increase for the month, which means there is no net increase in wages spending by that store. And if a casual employee picks up an additional shift for the Boxing Day trade or for having to pack the shelves on Christmas, they will lose that in later shifts. So for the retail workforce, there will not be an overall net income increase. The second canard, of course, is this notion of choice. As I indicated earlier, there is no real choice for workers in insecure work or even part-time employees who might be underemployed and who need the work they've got. The fact is, workers in insecure work feel, at least indirectly, the pressure to work when their employer makes a request. They have no meaningful or real industrial right to resist a request. You don't have to move to coercion when the employer asks. Casual workers, fractional workers know that if they're not convenient, then when future rosters are being made up, when that worker needs additional shifts to meet the needs of their family, they know their concerns and considerations will go to the bottom of the pile unless they are a worker convenient to the employer's need. So the mere economic relationship is the coercion, is the pressure. You don't need the employer to be overbearing or to do anything that would transgress the law. The situation itself will coerce vulnerable workers to have to agree, not just to the Boxing Day work, but to working on Christmas Day, packing the shelves, and working on the other days, should the employer choose to receive goods on those days and pack shelves. But more than that, and I'll come to this later, but the fact is that under the individual flexibility arrangements in place for workers, for example, in the Commonwealth Bank of Australia, they have provisions that state, quote, "You will work such hours as are reasonably necessary. We will inform you of the hours we need you to work from time to time, and these may change with our business needs. The base remuneration we pay you incorporates a component to compensate you for any additional hours you may work. You may from time to time be required to work on a public holiday," unquote. It's estimated that this kind of employment arrangement covers up to 90% of the Commonwealth Bank staff. That's, I think, some... and so what you see there is a provision in a federal industrial instrument that really deprives those workers of any capacity to resist a request from the employer to work on public holidays. They've lost that right in the federal instrument. The only thing protecting them, Mr. Deputy President, is the state law that says when the shops can operate or not operate. So the notion at the heart of this bill that the protection will be that workers must freely elect to work is a complete and utter nonsense. It's a Trojan horse. It's a fig leaf to make some members feel okay about selling out the workforce, about selling out families in this state. The fact is, Mr. Deputy President, we don't live in a 24/7 economy. Privileged parts of the community protect their weekends and their public holidays. But if this bill passes, what we will be saying is it's okay for retail workers and those who work in the banking and finance sector to lose those rights. The fact is that there has to be a dividing line between economic life and our role as workers and personal, family and community life. And at the moment, that dividing line is 4.5 days only. And yes, in Sydney City, Broadway and other locations, for historical reasons, some so-called tourist areas are freed of that restriction. Some people are saying, well, that's unfair. It's unfair that, you can go and shop in the city, but you can't in Western Sydney. It's okay to go shopping in Shell Harbour, but you can't in Wollongong. The fact is, those restricted areas have existed for a long time, and people who want to shop can easily have access to those places. But it's also an important protection because with only limited retail outlets operating, for those shops that do operate, there is, at the moment, a reasonable degree of surety that the workers who do work on those days in those locations are voluntary. Many shops are part of chains. When there is to be this limited trading on these days, those shops are able to cast across a wider metropolitan area amongst their existing workforce, looking for volunteers to work on these limited days. But if you move to a situation where there are no restrictions across the whole of the state, those shops, including particularly the chains, they will not just be looking for a handful of workers to work in these locations. They will have to rely on their regular workforce, which means that even those employers or shops that want to only have volunteers will have to move beyond the true volunteers because they will need to have sufficient staff to operate. And this is, of course, one of the vices in the bill. The claim, of course, as I indicated, was that to open on Boxing Day will be conditional on staff freely electing to work without coercion or threats. As I've indicated, you don't need to get there. The voluntary work protection is not new. It's existing in sections 7, 13 and 14, as I've indicated, but the real life experience of workers is different. There really is no ability to resist, and as I've indicated, those federal instruments remove whatever autonomy they have. The issue about the exposure to penalties is laughable, because the penalties, whether we're talking $5,500 or 50 penalty units for breach of an exemption condition, or the $11,000 penalty that applies otherwise, are relatively low compared to the massive profits that retail chains stand to make from trading. But the fact is, and that's just the trading turnover they currently have, and as I said earlier, the only fine so far handed out is $500 to JB Hi-Fi. So the risk of being caught or prosecuted is very low, and the fine is not a disincentive when you look at the profits that retail make. Government says that they do not expect to be overwhelmed by complaints. Well, that's an obvious point, because the employers will not need to coerce their workforces, because the insecurity of their employment will dictate that they'd have to acquiesce to these requests, to say nothing of the fact that the federal instruments they work under deprive them of any ability to resist in the first place. There will be no capacity to complain, because on the surface they will have agreed. So there'll be no basis for any prosecution. Mm-hmm. The government also says that it will not remove restrictions on retail trading around other public holidays, Christmas Day, Easter Sunday, Good Friday or Anzac Day morning. I think the Minister said this is an ironclad guarantee. Mm-hmm. Well, with due respect to the Minister, he didn't read Section 8, capital A, which provides that on each of those days, employers, shops, can operate for the purposes of receiving goods and having their shelves stacked. The restriction that the bill provides about trading to the public is what applies for Boxing Day only, but preparing your shop for trade will now apply across the board. The bill changes the definition of retail trading, and in so doing removes restrictions on people having to work behind closed doors filling shelves on Christmas Day, Good Friday, Easter Sunday and before 1 p.m. on Anzac Day. Section 8, capital A, expressly permits work on each of these days. So the question is whether the government really thinks that the loss of family time or the chance of attending a religious service is any less because you're in a shop with closed doors packing shelves rather than serving the public. These are very significant community and family days, but the freely elect to work notion in the bill is completely illusory, and the legislation rips away all the protections for thousands of retail workers and those working in banking and finance. The fact is, the bill does not measure up to the claims advanced by the government. It should be rejected to preserve what very limited guaranteed family and community time that workers in the retail, banking and finance sector currently enjoy. There is a complete social downside that will be created by this legislation, and there is no economic upside. This is just a blind ideological move by the government because they hate any regulation of industry. Yes, I acknowledge that interjection. Now, the fact is that there are, apart from, and while much of the focus on this legislation has focused on general shops and retail, as I indicated, if anything, the effects on people working in banking and finance is even worse. There are over 175,000 finance workers in this state who are at risk of losing this important time with their family. Those members are predominantly low-paid women, many working part-time, which of course is true for retail workers. The bill will open bank branches on weekends without the current rights of consultation that workers currently have. It will open bank branches on all public holidays other than those restricted days, which will cut bank workers' public holidays to 3.5 days only in the year. But it also removes the right to the August bank holiday as well as to the Boxing Day public holiday. And that's a significant additional blow to workers in banking and finance. So it's a very significant backward step for those workers, and it's not one that has received much consideration. Again, in the proposed section 14, capital C, capital A, the government rests on this notion of freely elect to work requirement, which is said to afford the protection. Well, as I indicated, in the banking and finance sector, their industrial instruments with the individual flexibility arrangements provide that those workers don't really have the ability to resist because there is that catch-all that says you must work essentially as needed and as notified, including on public holidays. So the only protection they have is whether under state law the shops, including the banks or the finance outlets, are allowed to operate. So you've got the fact that these workers, like retail workers, have limited to no bargaining power, and what little protection they're going to have, or that they currently have, is going to be removed. So we're taking away a holiday entitlement from workers employed by some of the most biggest and powerful institutions, and the big four banks combined are on track to make profits of in excess of something like $30 billion this year, and we're removing what few protections their workforces currently have by removing the Boxing Day public holiday and the August bank holiday.
Order.
As well.
It being 7 p.m, proceedings are interrupted to permit the Minister to move the adjournment motion if desired.
Mr Deputy President.
Oh, Minister.
To suit the convenience of honourable members, I do now suggest you leave the chair